Hello everyone, good day and mabuhay. This is Burton Joshua Ikdang, your legal aspect chancellor for today. And for today, we're going to discuss all about hospitality and tourism transportation. Philippines is known to be rich in natural resources and minerals, good culture and tradition. Given the proper funding and attention by the government, foreigners would not hesitate to visit the country and enjoy its natural beauty, different tourism amenities and facilities, and hospitality of its people. But we must not forget that despite the blessing that we have, calamities and different disasters as well as the negligence of people may be considered as factors that could affect both the sectors of tourism and hospitality.
Samantala, inihahanda na ang muling pagpapalaot ng pagoda para sa pista ng mahal na cruise sa Wawa sa Bukawi, Bulacan. Inilatag na ang mga hakbang para tiyaking hindi na mauulit ang trahedya noong taong 1993 kung saan mahigit 300 ang namatay. Nakatutok si Lia Manyalak del Castillo.
Mga panagboy at hiyaw ng pagmamakaawa at paghingi ng tulong ang umalingaw-ngaw nang lumubog ang pagoda sa ilog ng Bukawi, Bulacan noong 1993. Ang dapat sana'y masayang selebrasyon ng pista na uwi sa trahedya nang malunod at mamatay ang halos 300 tao. Karamihan mga deboto ng mahal na krus sa Wawa. Isinisi ang tinaguriang pagoda tragedy sa overcrowding at depektibong pagkakagawa umano ng pagoda. Sa loob ng maraming taon matapos ang trahedya,
nagpabot po ng pakikiramay at panalangin si Pope Francis sa mga biktima ng trahedya sa Cebu. Idinetali naman ng dalawang Sea Marshal na nakasakay noon sa MV Sulpicio Express 7 ang pangyayari bago at matapos ang pagsalpok nito sa MV St. Thomas Aquinas. Nakatutok si Jam Cesante.
Inunang sagipin ang mga sanggol at batang pasahero mula sa MV St. Thomas Aquinas matapos makasalpukan ang MV Sulpicio Express 7. Kwento ng Sea Marshals na nakasakay noon sa Sulpicio, kasalubong nito ang Aquinas na nooy palayo na sa Cebu. Pakanan daw ang Aquinas nang sumalpok sa stem o harapang bahagi ng Sulpicio. Nawalan ng kuryente ang Aquinas habang kumaskas sa gilid nito ang Sulpicio. Umabot hanggang sa engine room at lalagyan ng langis ng Aquinas ang pagkaskas. Dahil dito, nagsimula ng tumagilid at lumubog ang Aquinas. Sa takot na sumama sa paglubog, dahan-dahang iniatras ng crew ang Sulpicio. Pagkaalis, saka na tuluyang pinasok ng tubig at lumubog ang Aquinas.
Causes of this accident other than fortuitous events were overloading, aging facilities, badly trained crew members, and poor compliance by the vessels and aircrafts with safety precautions and measures. So this topic will equip us tourism students with legal background about transportation as the same as an inevitable means of effective tourism and hospitality management. So along with this topic, we will going to discuss about the definition of transportation, the elements of common carrier, the characteristic of common carrier, degree of diligence required to a common carrier, period wherein the degree of extraordinary diligence should end, common carrier absolved from liability, and different government agencies related to the business of common carriers. So being a tourism student, we all know about traveling, going from one place to another. But what is transportation? Transportation is one whereby a certain person or association of persons obligate themselves to transport persons, things, or news from one place to another. And this is actually classified into two, which are the common carrier and the private carrier. What is common carrier and what is private carrier? We will going to discuss that later on. Common carrier. So from the word itself, common, what comes into your mind? Probably public. This common carrier actually are persons or corporations, firms or associations engaged in the business of carrying or transporting passengers or goods, or both by land, water, or air for compensation, offering their services to the public. It's right under Article 1732 of the Civil Code of the Philippines. Furthermore, a common carrier is a service open to the public or to the general public. Typical examples of common carriers include actually the ship owners, railroad, airline, taxi service, buses, vans, etc. On the other hand, what is private carrier? Private carrier are those who transport or undertake to transport in a particular instance for hire or reward. Or in other words, private carrier is a company that transports only its own goods. To fully understand the topic, I'll be discussing to you the differences of common carrier and private carrier. So for the common carrier, it holds himself out in common, that is to all persons who choose to employ him as ready to carry for hire, while private carrier agrees in some special cases with some private individual to carry for hire. The common carrier is bound to carry for all who offer such goods as it is accustomed to carry and tender reasonable compensation for carrying them, while private carrier it is actually not bound to carry for any reason. The next one is common carrier is for public service and subject to regulation, while on the other hand, private carrier is not for public and it is not subject to any regulation. Lastly, common carrier is required to exercise extraordinary diligence, while private carrier is not required to render any extraordinary diligence. What is extraordinary diligence, by the way? We will going to discuss that later on, but just a clue, extraordinary diligence is about giving an extraordinary care to a good or to a person when you are delivering something or transporting something. So what are the elements of common carrier? First, it is a business of transportation. Like I've mentioned earlier, the typical example for this one are buses, vans, taxi, any public service. Second, it is for compensation. So we are obliged to pay for this, or it is for hire. And the last one, it is for public service. Like I mentioned, since it is a common carrier, it is for public use or public service. So from the elements of common carrier, let's move on to characteristic of a common carrier. First one, it is regarded to some extent as a public servant, which means to say he is bound to serve all who apply and is liable for refusal without sufficient reason to do so. Second, it cannot lawfully decline to accept a particular class of goods for carrier to the prejudice of the traffic in those goods. Meaning, however, can do so where for some sufficient reason the discrimination in such goods is reasonable and necessary under all circumstances of the case. Third, common carrier does not have monopoly, or no monopoly is favored, Well, monopoly is a dominant position of an industry or a sector by one company to the point of excluding all other viable competitors. So the Public Service Commission has the power to say what is reasonable rule for the convenience of the traveling public and to enforce them. And lastly, common carrier is a public convenience. It gives public service to the people. To further discuss about the provision of the civil code and the laws abiding on these topics, I will going to give you a fun fact about what is the civil code of the Philippines. It is actually the product of codification of private law in the Philippines. It is the general law that governs family and property relations in the Philippines. It was enacted in 1950 and remains in force to date with some significant amendments. By the way, the articles that I'll be discussing right now is under obligation and contracts. It's actually a continuation with the report of Ms. Rial. It's under section 4, subsection 2 and 3, chapter 3, wherein it talks about work and labor of the Civil Code of the Philippines. So now let's move on to the degree of diligence required to a common carrier. First, the degree of diligence demanded upon from the common carrier is the extraordinary diligence. It is under Article 1733 of the Civil Code of the Philippines, which common carriers, from the nature of their business and for reasons of public policy, are bound to observe extraordinary diligence in the vigilance over the goods and for the safety of the passengers transported by them according to all the circumstances from each case. So, as a business entity in the tourism industry, the satisfaction of the customers should be a primordial consideration in order to achieve success. The public must, of necessity, rely on the care and skill of common carrier in the vigilance over the goods and safety of the passenger. That is why it is an extraordinary diligence. Now let's go with the responsibilities of a common carrier. Article 1737, it talks about the common carrier's duty to observe extraordinary diligence over the goods remains in full force and effect even when they are temporarily unloaded or stored in transit, unless the shipper or owner has made use of the right of stoppage in transit. What is the right of stoppage, by the way? Another responsibility of a common carrier is right down in Article 1740, which, if the common carrier negligently incurs in delay in transporting the goods, a natural disaster shall not free such carrier from the responsibility. And in Article 1741, if the shipper or owner merely contributed to the loss, destruction, or deterioration of the goods, the proximate cause thereof being the negligence of the common carrier, the latter shall be liable in damages which, however, shall be equitable or equitably reduced. Another provision of law wherein responsibilities of a common carrier is right down in Article 1744, which a stipulation between the common carrier and the shipper or owner limiting the liability of the former for the loss, destruction, or deterioration of the goods to a degree less than extraordinary diligence shall be valid provided that it be in writing, signed by the shipper or owner. Second, it's supported by a valuable consideration other than the service rendered by the common carrier. And lastly, it is a reasonable, just, and not contrary to public policy. It's actually right under subsection 2, vigilance over goods. The last two articles, which right under the responsibilities of common carrier, is under subsection 3 of safety and of passengers. Article 1755 stated, a common carrier is bound to carry the passenger safety as far as human care and foresight can provide, using the utmost diligence of very cautious persons with a due regard for all the circumstances. And Article 1756, in case of death or injuries to passengers, common carriers are presumed to have been at fault or to have acted negligently unless they prove that they observe extraordinary diligence as prescribed in Articles 1733 and 1755.
These rules on presumption. It is presumed that the carrier was negligent. I'm emphasizing this because again this is a favorite in the bar. Paulit-ulit yan. Minsan hindi natin napapansin kung ano yung issue, but usually ito lang yung issue. Do you have to prove negligence? Do you have to prove proximate causation? Proximate cause. Okay. So because of this presumption, the rule on proximate cause, as we apply this rule in Civilo, in the general principles of Civilo, it's not applicable. So, all you have to prove, as I already emphasized earlier, na-receive nung carrier yung goods o sumakay yung passenger. Ang kailangan mo lang i-prove is the contract, the perfection of the contract, and the damage or injury. And the damage or injury may be in the form of actual damage to the property or delay in the receipt of the goods, or you did not actually receive the goods. Merong misdelivery. It was delivered somewhere else. The moment you prove that, in law may connection na kagad sa dalawa. You don't need to prove negligence and you don't need to prove that this negligence is the proximate cause of the damage or injury. Now, relating it just to see the difference, in a case for quasi-delict, you have to prove basically three: negligent act or omission, second, causation, and third, damage. You have to establish the connection between the three. So if you are damaged, you have to prove that somebody else was negligent and this negligence caused the damage. So konektado yung three requisites. In the case of common carrier, you don't need to do that. Medyo mas madali initially. You have to prove that there is a contract and there is already control on the part of the carrier. Yung goods nasa kanila na. They are now in possession or in control of the goods. You are already embarking or in the vehicle itself as a passenger. And then you prove that there is damage. Nasugatan ka na hindi ka nakarating dun sa destination. The goods are now destroyed. The boat sank and the goods were not delivered to you. This is all that is necessary. You don't need to prove negligence. You don't need to prove that this negligence caused the damage. Okay, so that is the importance of the presumption of negligence, which, as I said, was involved in many bar examination questions as well as the cases decided by the Supreme Court.
So now let's move on to the period wherein the extraordinary diligence should end. In Article 1736, it talks about the extraordinary responsibility of the common carrier lasts from the time the goods are unconditionally placed in the possession of and received by the carrier for transportation until the same are delivered, actually or constructively, by the carrier to the consignee or to the person who has a right to receive them without prejudice to the provision of Article 1738. For example, a taxi driver cannot refuse to deliver its passenger to its intended destination unless a situations fall under Article 1734 of the Civil Code of the Philippines, which Article 1734 will be discussed later on the common carrier absolved from the liability. Second, period wherein the extraordinary diligence should end. It is right under Article 1738 wherein the extraordinary liability of the common carrier continues to be operative even during the time the goods are stored in a warehouse of the carrier at the place of destination until the consignee has been advised of the arrival of the goods and has had reasonable opportunity thereafter to remove them or otherwise dispose of them. So in contrast to this, the law also provides that the common carrier's duty to observe extraordinary diligence in the vigilance over the goods remains in full force and effect until they are temporarily unloaded or stored in transit, unless the shipper or owner has made use of the right of stoppage in transit. Now let's go with the common carrier absolved from liability. Number 1, Article 1737 of the Civil Code of the Philippines states that common carriers are responsible for the loss, destruction, or deterioration of the goods unless the same is lost due to any of the following causes only. First one is flood, storm, earthquake, lightning, or other natural disaster or calamity. Second, an act of the public enemy in war, whether international or civil. Third, it is an act or a mission of the shipper or owner of the goods. And lastly, an order or act of competent public authority. So to take note about this one, it must be noted that in all cases, other those mentioned above, if the goods are lost, destroyed, or and deteriorated, common carriers are presumed to have been at fault or to have acted negligently unless they prove that they observe extraordinary diligence in the performance of their duties and responsibilities. Furthermore, in number 2, Article 1743, if through the order of public authority the goods are seized or destroyed, the common carrier is not responsible provided said public authority had power to issue the order. So for the last part of our discussion, let's go with the different government agencies related to the business of common carriers. On this particular logos, what can you observe? Now, I'll be discussing to you each logo and the meaning of these logos. DOTC, or Department of Transportation and Communication, or in Filipino, it Kagawaran ng Transportasyon at Komunikasyon. It is under the umbrella of the Executive Department of the Philippines government, wherein it is responsible for the maintenance and expansion of viable, efficient, and dependable transportation and communication system as effective instrument for the national recovery and economic progress, and it is also responsible for the country's rail, air, sea, and communication infrastructure. This is LTO, or the Land Transportation Office, wherein it is under the OTC, attached agency responsible for the licensing of the public land transportation services. LTFRB, or the Land Transportation Franchising and Regulatory Board. or in Filipino, it's lupon sa pagprapangkisa at regulasyon ng transportasyong lupa. It is an agency of the Philippine government attached to the DOTC responsible for promulgating, administering, enforcing, and monitoring in compliance of policies, laws, and regulations of public land transportation agencies. Next one is Marina, Maritime Industry and Authority, or in Filipino, Pangasiwaan ng Kalakang Pandagat. It is an agency of the government under DOTC responsible for integrating the development, promotion, and regulation of the maritime industry in the Philippines. ATO or ATO or Air Transportation Office, or in Filipino, Tanggapan ng Transportasyong Himpapawid. It is an agency of the Philippine government under the DOTC responsible for implementing policies on civil aviation to assure safe, economic, and efficient travel. Next one is the Philippine Coast Guard, or in Filipino, Tanod Baybayin ng Pilipinas. It is the Coast Guard of the Philippines involved in the border enforcement of maritime laws in the country, especially against smuggling, illegal fishing, and drug trafficking. It is also involved in maritime search and rescue, or SAR, missions, as well as the protection of maritime environment. PNR, or Philippine National Railways. It is a state-owned railway system in the Philippines organized under the DOTC. As an attached agency, it was established during the Spanish colonial period, and the modern PNR was developed around 1,060 kilometers track on the island of Luzon, where most Philippine rail infrastructure is located. It forms the backbone of all of Metro Manila regional rail services, which extend to its suburbs and to province such as Laguna. MRT, or the Metro Rail Transit Corporation, is a private consortium responsible for the maintenance of the Manila Metro Rail Transit system. It is also the original contractor for the MRT project, and it runs the MRT in coordination with the DOTC. Next is the LRTA, or the Light Rail Transit Authority, which it is a public transport operation in charge of operating and maintaining the Manila LRT system. Founded on July 12, 1980, it is also responsible for monitoring the progress of construction of all LRT lines. It is not, however, in charge of the upkeep of the Manila MRT system, or MRT3. Those duties are relegated to the MRT Corporation, a private enterprise under MRT3 Build, Operate, Transfer Agreement. Although it has the naming format of a government agency, the LRTA is organized as a government-owned or controlled corporation under still the DOTC as attached agency. NAIA, or the Ninoy Aquino International Airport, or in Filipino, Paliparang Pandaigdig ng Ninoy Aquino. In IATA, the acronyms are MNL, and in ICAO, it is RPLL. It is one of the international gateway of the Philippines, currently known as Diosdado Macapagal International Airport, or DMIA. It caters mostly to low-budget airlines serving Manila, but definitely plans to transfer full operation of NAIA to DMIA, or the Diosdado Macapagal International Airport, has been implemented. This is actually way back in 2010, I believe. But currently, right now, we have a news that they are bringing back the Manila International Airport as the current name of NAIA. Next is the Mactan Cebu International Airport, or in Filipino, the Paliparang Pandaigdig ng Mactan, Cebu. Well, in Bisaya, it's the Tugpahanang International sa Mactan, Sugbo. IATA, it is CEB, and in ICAO, it is RPVM. It is a major international airport in the Visayas region of the Philippines, located in Lapu-Lapu City and in Mactan Island, and also in Metro Cebu. It is the country's second primary gateway. And the last one is the PPA, or the Philippines Ports Authority. Or in Filipino, it's Pangasiwaang Pilipino sa Mga Daungan. It is an agency under the Philippine government, under the Department of Transportation and Communication, or DOTC, responsible for financing, management, and operation of public ports through the Philippines. So that's it for today. I hope you learn a lot about all the provision, the articles I have discussed earlier, and as well as the different agencies that is under the transportation. I hope you learn a lot in this discussion, and thank you so much for listening. This has been Bert and Joshua Ikdang. Goodbye.